Welcome to Talk Trials.
It's great to be here.
Before we even get into today's case, I was thinking about just how much trust we put into these little chips in our phones, in our computers. We save everything, pictures, critical work documents, and we just have this blind faith that the data will be there tomorrow exactly as we left it.
It really is an illusion, isn't it? We see this solid state drive and it seems so permanent, so stable, but at the microscopic level, it's just pure chaos.
It's basically a leaky bucket.
That is the perfect analogy, a leaky bucket. Flash memory works by trapping electrons to represent a 1 or a 0. But, physics gets in the way.
Right.
Electrons leak out, voltages drift, things get hot. And over time, a 1 can just flip and become a 0, or a 0 becomes a 1.
And if that happens in the right file?
It's catastrophic. Your beautiful photo of a sunset is suddenly a mess of digital static. Or worse, the flight control software on a plane gets a corrupted value.
So there has to be something protecting us from that chaos.
There is. There's this constant invisible war being waged against entropy inside every chip. And it's all run by incredibly clever math. And that math, the system's designed to fix those errors before we ever even know they happened. That's what today's deep dive is all about.
So we're looking at the invisible armor that holds our digital world together.
We are. And we're also looking at a huge legal fight over who gets to own a piece of that armor.
This is Kioxia Corporation v. Viasat, Inc.
That's the one. Appeal number 2024-1384 from the Federal Circuit.
And these are not small players. Kioxia is a giant in flash memory. They used to be Toshiba's memory division. And Viasat is a massive global communications company.
Exactly. When you see names like this on a case, you know the stakes are incredibly high. But what makes this case so interesting for us is that it's not just a fight over technology. It's also, I would say, a procedural horror story.
A horror story.
For the lawyers, I think so, yes.
Right.
It's a perfect case study in how a legal strategy can just completely fall apart if you're not careful.
I love those.
We're going to see this huge battle over the definition of a single, simple-sounding word, decode. And then we get a masterclass in what we call the reply brief trap.
The procedural traps. It's like watching a chess game where a player makes a move and then, just freezes because they realize they've just blundered their queen.
That's a very, very good way to put it. That's exactly what it feels like happened here.
Okay, so set the stage for us. Where did this all begin?
It started, as many of these do, with an inter partes review, an IPR.
So not in a regular court. This is at the patent office.
Correct. Viasat holds U.S. patent number 8,615,700 patent. We'll just call it the 700 patent. Kioxia, wanting to invalidate that patent, filed a petition with the Patent Trial and Appeal Board, or the board.
They wanted to kill the patent.
They wanted to kill it. They argued it wasn't new, that the invention was obvious. The board heard all the arguments, and, well, they sided with Viasat. They said the claims were valid.
And Kioxia obviously didn't like that answer.
Not at all. So they appealed to the Federal Circuit, which is how it landed on our desk.
Which brings us to the two big questions for today.
Right. Question one is the techie one. What does it actually mean to decode data? It's just holding it for a moment. Does that count?
And the second question is the procedural one.
Yep. Can you completely change your legal theory in the middle of an appeal? Can you, swap horses midstream when you realize your first one is sinking?
I'm going to go out on a limb and say the answer is probably no, but I'm fascinated to hear why.
We'll get into it.
Okay, let's do the snapshot first. Just the high-level takeaway. What was the final holding?
The holding was a clear affirmance. The Federal Circuit agreed with the board. Viasat wins. The challenge claims of the 700 patent all survive.
So Kioxia's appeal was a total loss.
A total loss. Specifically, it was claims 2, 10 through 14, 16, and then 23 through 25 that were upheld.
Got it. And who was on the panel?
It was Circuit Judges Chen, Bryson, and Cunningham, with Judge Chen writing the opinion.
Now, I saw a note here that this opinion is non-precedential. For anyone listening who might be tempted to tune out, why should they stick with us?
That's a great question. Because people see non-precedential and they think, oh, it doesn't matter. But that is such a mistake.
How so?
These opinions are where the court often reinforces the rules of the road. It's where they send clear messages to the lawyers who practice before them. This case in particular is a bright, flashing warning sign about forfeiture and appellate procedure. If you're a litigator, this is required reading. It shows you exactly where the landmines are buried.
Okay, so it's a practical lesson. And there was something about mootness, too. Some other claims.
Yeah, just a bit of procedural cleanup. Some of the original claims, Kioxia challenge-like claims 1, 4, 8, and a few others, were actually invalidated in a completely separate IPR proceeding.
So they were already dead by the time this appeal was decided.
Exactly. The court basically said, we don't need to rule on these, they're already gone. So the appeal for those specific claims was moot. Our focus is on the depending claims that were left standing.
Okay, that makes sense. We've got the headline, Viasat wins, Kioxia loses. Now let's get into the why. This is the deep dive, the case unpacked.
And to do that, we have to start with the technology.
Yeah.
You really can't understand the legal arguments until you understand forward error correction.
Okay, let's go back to your leaky bucket analogy. We've got this unstable flash memory, bits are flipping. How does the Viasat patent claim to solve this?
It's a method that involves adding what are called parity bits. It's a form of redundancy.
Okay.
So when you go to save your data, say that photo again, the system doesn't just write the ones and zeros of the photo to the memory. It first runs that data through a special math algorithm.
And that algorithm spits out what?
It spits out extra bits, parity bits, redundant information that describes the original data. This whole process of adding the protective data is called encoding.
Let me see if I can put that in simpler terms. If my message is the word talk, I don't just save T-A-L-K. I might add an extra character at the end that says, this word has one vowel.
That's a perfect simple example. Yes, that one vowel information is your error correction code.
So you're packing the data with its own instruction manual for how to fix itself.
That's a great way to put it. Now fast forward. You go to read the data. But because of that electron leakage, the memory now says T-O-L-K. The A has flipped to an O.
The data is corrupted.
It is, but if you have a decoding system, it doesn't just blindly accept T-O-L-K. It reads T-O-L-K, and then it reads your error correction code that says this word has one vowel.
And it sees a conflict. T-O-L-K has one vowel, but it's an O, not an A. The math is more complex. But
Right. The decoder does the math, and it says, wait a minute, the parity data doesn't match T-O-L-K. Based on this code, that second letter must have been an A, and it fixes it on the fly.
It rebuilds the original correct data.
It reconstructs the truth. And that whole active process, taking the corrupted data, using the parity bits to find and fix the error, and then stripping those parity bits away to give you just the clean data that is decoding.
Okay, I'm with you. It's an active computational job. It's doing work.
It absolutely is. And that gets us right to claim 1 of the patent, which requires a decoding module configured to decode the received encoded data.
Seems pretty clear. So how on earth did Kioxia build an argument against that?
Well, they pointed to a piece of prior art, an older patent by someone named Lee. And they argued that Lee already did this.
So Lee had a decoding module.
Not exactly. This is the heart of the fight. Lee's system had a component. And Kioxia's entire case, at least on this point, was built on convincing the board that this component in Lee was a decoding module.
But did that component in Lee actually, fix the TOL back to talk?
That is the million-dollar question.
Yeah.
And the answer is no. The component in Lee was, for all intents and purposes, a buffer.
A buffer. Let's define that.
A buffer is just a temporary holding area. It's a very common thing in computer hardware. Think of it like a waiting room.
Okay.
Data comes in from one place, it sits in the buffer for a tiny fraction of a second, and then it goes out to another place. It's there to manage the flow of traffic. The data that comes out is identical to the data that went in.
So you don't get surgery in the waiting room.
You do not get surgery in the waiting room. No work is done on you. You just sit there. And that's what a buffer does. It just holds the bits.
So Kioxia's argument was that the waiting room is the operating room.
Essentially, yes. Their argument was that the term decode should be interpreted so broadly that it includes mere buffering. That the act of receiving and holding the data, even for a moment, should count as a step in decoding, and therefore the buffer itself is a decoder.
That seems like a really tough argument to make. Why would they even try that?
Because that was their only path to victory. If buffering equals decoding, then the Lee patent, which clearly shows a buffer, anticipates Viasat's patent.
And if it's anticipated, it's invalid.
And Viasat's patent dies. It's a classic strategy. Try to stretch the meaning of a claim term so that it reads on the prior art.
But the board didn't buy it.
Not for a second. The board went straight to the foundational principle of claim construction, ordinary meaning.
This is a huge deal in patent law.
It's everything. The rule is that words in a patent claim are given their ordinary and customary meaning, the meaning they would have to a person of ordinary skill in the art, an engineer in that field.
Unless the patent owner specifically redefines the term.
Right. A patentee can be their own lexicographer, but they have to be really clear about it. If they don't, we stick with the ordinary meaning.
And to an electrical engineer, decode means?
It means the opposite of encode. It's that computational process of error correction. It's not just storage. And the board found that buffering alone just isn't that.
I read that Kioxia's own expert witness kind of sealed their fate on this.
He really did. It must have been a painful cross-examination. The board essentially cornered him. They asked, point blank, if a buffer by itself performs decoding.
And what did he say?
He had to concede that while a decoding process might involve buffering at some point, the act of buffering alone is not decoding.
So he admitted that being in the waiting room isn't the same as having surgery.
You're really getting a lot of mileage out of that analogy.
Hey, if it works, it works. It clarifies that passive versus active distinction.
It does. But Kioxia wasn't done. They had one more argument on this point. They pointed to the text of Viasat's own patent.
The specification.
Right. And there was a sentence in there that said, the processor in the invention may buffer, de-interleave, or perform certain aspects of the decoding process.
Ah, I see what they're doing. They're saying, see, Viasat put buffer in the same list as decoding. They're admitting they're the same thing.
That's the argument. It's called the embodiment argument. Because one example, one embodiment of the invention mentions buffering. They tried to use that to redefine the core claim term.
How did the Federal Circuit deal with that one?
Judge Chen dismantled it very elegantly. The court drew a sharp line between what a thing is and what a thing may do.
Okay, break that down for me.
The court said that sentence is just a list of possible functions. It's a menu of capabilities. A decoding module may perform buffering. It may de-interleave. It might also have an LED light on it. But listing those ancillary functions doesn't change the definition of what the thing fundamentally is.
So just because my car has a cup holder, that doesn't mean the definition of car is a thing that holds cups.
Precisely. The primary function defines the term, not the secondary features. The court concluded that Viasat never clearly departed from the plain and ordinary meaning of decode. So decode means the math, the error correction. Buffering is just buffering. Claim 1 survives.
Okay, so that's a big loss for Kioxia on the main technical point. But they didn't give up. They pivoted to Claim 15.
They did. And this is where the case shifts from a tech debate to, well, to a lesson in appellate litigation strategy.
Claim 1 uses the term decoding module. Claim 15 uses decoder. I mean, to a layperson, that sounds like exactly the same thing.
And to 99% of engineers, it would be. But Kioxia, having lost the argument on decoding, tried to argue that decoder was different.
How could it possibly be different?
Their argument was that decoder is a structural term, a noun, a box. And they argued that this box doesn't necessarily have to perform the full decoding function from Claim 1.
Yeah.
They're trying to separate the noun from the verb it's based on.
That sounds desperate, like saying, I'm a baker, but that doesn't mean I actually have to bake anything.
It was an act of desperation. But here's the kicker. The Federal Circuit didn't even touch the merits of that argument.
Right.
They didn't decide whether decoder and decoding module were the same or different.
Why not?
Because they decided Kioxia wasn't even allowed to make that argument in the first place.
And this is the forfeiture.
This is the forfeiture, and this is the part of the deep dive that every lawyer listening needs to pay very close attention to.
So walk us through the procedural history. Forfeiture is all about timing, right? It's about when you say something.
It's all about timing and consistency. So let's rewind. Stage 1, the IPR petition. This is the document Kioxia filed at the very beginning to start the whole process. In that petition, when arguing about Claim 15, Kioxia explicitly tied it to Claim 1. They basically said, our argument for invalidating Claim 15 is the same as our argument for Claim 1, see above.
So from day one, they treated them as a package deal. They handcuffed them together.
They did. Then, Stage 2, their opening brief to the Federal Circuit. This is their first big shot on appeal. And they did it again. They repeatedly linked decode from Claim 1 with decoder from Claim 15. Their whole argument was the board defined decode wrong, and since decoder is the same thing, the board was also wrong about Claim 15.
So for months, through multiple legal filings, their consistent position is these two things are linked.
Unambiguously. Until the reply brief.
Which is the final filing, their last word on the matter.
The very last word. And in that brief, Kioxia did a complete 180. They suddenly argued that the board made a mistake by linking the two terms. They tried to introduce this brand new theory that Claim 15's decoder should have been analyzed separately as a structural element.
So petition, they're the same. Opening brief, they're the same. Reply brief, wait, no, they're different, and the board was wrong to treat them as the same.
And the Federal Circuit's response was a swift and decisive no.
Why is the rule so rigid? I mean, don't lawyers refine their arguments as a case goes on?
They can refine, but they cannot rewrite the entire story at the last minute. It's a practice called sandbagging, and the courts hate it.
Sandbagging.
Think about it from a fairness perspective. Viasat wrote its response brief based on what Kioxia argued in its opening brief.
Right. They defended against they're the same theory.
Exactly. They spent all their time, money, and pages rebutting that specific argument. If Kioxia can then introduce a totally new, their different theory in their reply brief, Viasat is left with no chance to respond. They've been ambushed.
It undermines the whole adversarial process.
Completely. The court is left with one side's brand new argument and no counter-argument from the other side. That's not how you get to a just result. The rule is simple. Arguments raised for the first time in a reply brief are forfeited. You waived your right to make them.
So because Kioxia chose to link the claims in their opening brief, they were stuck with that choice.
They were stuck. And since the court had already decided that decoding isn't buffering, and Kioxia's own argument linked decoder to that same definition, claim 15 went down with the ship.
Wow. That is a brutal outcome. A potentially clever argument just gone because they made it too late.
Too late is the story of so many failed appeals.
And there was one more procedural issue, wasn't there? Something about retrieving and receiving.
Yeah, a third and final forfeiture argument. This one was a bit different. It had to do with claims 15 and 17, which talk about the decoder retrieving or receiving data from the flash memory. On appeal, Kioxia tried to argue that the board improperly read a limitation into the claim, that the decoder had to get the data directly from the flash memory with nothing in between.
And the court threw this one out as well?
They did. But not because it was a reply brief switch. This was a different flavor of forfeiture. Failure to develop an argument.
What does that mean, failure to develop?
It means you can't just hint at an argument and expect the court to do the work for you. In their opening brief, Kioxia sort of gestured in the direction of this argument. They might have had a single sentence or a footnote that mentioned it.
But they didn't flesh it out.
They didn't build a case.
Yeah.
They didn't cite the record, apply the law, connect the dots. An appeal brief isn't a treasure map where you leave clues for the judges to find. You have to present a complete, coherent argument.
You have to show your work.
You have to show all of it. The court basically said, you didn't make this argument in any meaningful way in your opening brief, so we're not going to consider it. It's like they're saying, we're not your co-counsel.
It's a court of review, not a court of do-over.
That's the perfect way to put it. So at the end of the day, Viasat gets a clean sweep. They won on the technology and they won on the procedure.
Okay, let's step back a bit for our legal context and significance segment. Beyond this specific patent, why does this case matter?
Two really big reasons, I think. First, on the claim construction side, this case is a powerful reaffirmation of the ordinary meaning principle.
Right.
We see this all the time, especially in tech. A company gets a patent, and then they try to stretch the definitions of the words to cover technologies that were invented years later by other people.
They want the patent to be a living, growing thing.
Of course they do. But this case puts a check on that. It says technical terms have real, established meanings to the people in that field. You can't just decide decode also means buffer because it helps you win a lawsuit. It provides certainty and keeps property rights, which is what a patent is, from becoming fuzzy and ill-defined.
It stops what you might call patent creep.
I like that phrase, patent creep. Yes. And second, and maybe more important takeaway is the procedural one. This opinion is like a foghorn blasting a warning to every litigator.
The reply briefs trap?
It's more than a trap. It's a fundamental principle of appellate practice. Your strategy has to be locked in by the time you file your opening brief. You might learn new things or think of better arguments later, but the Federal Circuit is telling you very clearly there's a hard deadline for deciding what your case is about.
So if you miss that deadline,
you lose. It's that simple. And it forces lawyers to think through their entire case from the very beginning. You can't just file an IPR and then figure out your best arguments on appeal. The theory you start with has to be the theory you end with.
It really highlights the need for a coherent strategy from day one.
Absolutely. Kioxia's attempt to unlink the claims at the last minute feels like a reaction to a bad decision from the board. It feels like panic.
And panic, as we know, is not a strategy.
It is not.
All right. We've gone through the tech, we've gone through the procedure. I think it's time we take our seats.
Let's do it.
Sitting as the 10th chair.
Sitting as the 10th chair. So for anyone new to the show, the Federal Circuit decides cases in panels of 3 judges. But here, we add ourselves to the bench to give our own reasoned judgment on the case. So, looking at the record in Kioxia v. Viasat, what's your vote?
It's an easy one for me. I vote to affirm.
Unanimous with the actual panel.
Completely. I see no error here at all.
Okay, give me the reasoning. Let's start with the merits, the decode versus buffering issue.
On the merits, I think the board and the Federal Circuit got it exactly right. In the world of computing and signal processing, the distinction between an active process and passive storage is fundamental. It's not a subtle point.
It's a bright line.
It is. A decoder does work, a buffer holds work. To conflate the two would just create chaos in claim construction. It would devalue the actual invention. Viasat's patent is about the clever math of fixing errors. If you let that be invalidated by an older patent that just shows a simple memory cue, you're rewarding the wrong thing. You're saying the patent system has to protect the actual inventive step.
It must. And the inventive step here was the error correction process, not the act of temporarily storing data. So on the tech, it's a clear affirm.
And what about the procedural forfeitures?
On procedure, I think the affirmance is even more important, frankly. The appellate system depends on order and fairness. When Kioxia told the board, analyze claims 1 and 15 together, they set the terms of the debate.
Right.
The board invested its time and resources doing exactly what Kioxia asked. For Kioxia to then turn around on appeal and say, you were wrong to do what we told you to do.
Yeah.
It's just untenable.
It feels like trying to have it both ways.
It is. And the forfeiture rule prevents that. It protects the resources of the judiciary, and it protects the opposing party from being ambushed. It ensures that the arguments the Federal Circuit hears are the same arguments that were tested and developed below. It's about systemic integrity.
So your vote to affirm is as much about protecting the process as it is about the specific outcome.
I'd say so, yes. Kioxia made a strategic choice. They have to live with the consequences of that choice. The court was right to hold them to it.
Well, I have to say, I'm right there with you. The 10th chair is unanimous. It's an affirmance across the board.
A good result for Viasat. And a cautionary tale for appellate lawyers everywhere.
And a good result for all of us who want our data to be properly decoded, not just stuck in a waiting room.
Well said.
Now, before we wrap up, we have to give our standard disclaimer.
We do. Please remember, everything we've discussed here today, including our judgment in the 10th chair, is commentary. It's for informational and discussion purposes only.
It is absolutely not legal advice, and we are not your attorneys.
And our analysis doesn't represent the official views of the Federal Circuit, even if we happen to agree with their conclusion this time.
If you have a patent issue, please go find a qualified professional.
Please do.
But we would love to hear what you think. Does this case stand out to you? Especially for the engineers listening. Is there a world where buffering could be seen as decoding?
Yeah, I'd be fascinated to hear if there's a technical counter-argument that Kioxia just failed to make properly. Is there some kind of smart buffer that blurs the lines?
Let us know. Leave a comment, send us an email. Until then, make sure your claims are well-defined.
And your reply briefs are consistent with your opening briefs.
We'll see you next time on Talk Trials.